One defendant hears an 8-year plea offer, and the judge says, not even close. Moments later, another defendant walks away with probation instead of prison. Why did the court treat these two cases so differently? Stay until the end to see what happened.
All right, in 26 CR 452, you are Jeremy Wayne Meekins.
Yes, sir.
And you are here with Mr. Kirk, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
All right. In summary, this indictment alleges that on or about February 24th, 2026, here in Jefferson County, Texas, it is alleged you committed a third-degree felony of assault, family violence by intentionally, knowingly, or recklessly causing bodily injury to a person who's a member of your family, household, or a person with whom you had a dating relationship, and you intentionally, knowingly, or recklessly impeded the normal breathing or circulation of the blood of the complainant by applying pressure to her throat or neck, or by blocking her nose or mouth and placing your hands around her neck and squeezing. This is what we called choking, which
This one was Reggie's.
there's only one intent, that's to seriously injure or kill someone when you squeeze their neck, because breathing comes in handy for human beings. It's a necessity of life. All right, so we've got a burglary of a habitation conviction in 08 out of Jasper County. After that became final, the defendant committed unlawful possession of a firearm by a felon and was convicted in Jasper County in February of 2010. So thereafter, anything after that, you're an habitual felon. The next paragraph states that after those first two convictions were final, you committed unlawful possession of a firearm by a felon, a third-degree felony, once again, and were convicted out of Jasper County in 2013. After that, third conviction was final. You committed the felony of burglary of a habitation and were convicted of that in May of 2022 in the 252nd District Court of Jefferson County. Next door. And also on that same date, you were convicted of another burglary, a second burglary of a habitation at that time. So you had the status of an habitual felon 3 convictions ago. And so now you're here with the third-degree felony of assault by choking somebody. Is all that about right?
Yes, sir.
The offer is 8 years? That it?
Yes, sir.
No. Not even close for this call. Even when you choke somebody, it's intended to kill them. 3 convictions ago, you were a habitual felon looking at 25 to life. 3 convictions ago. Not on my life. Set it for trial.
You know that.
Call cause number 26 CR 943 the state of Texas versus Antonio Valen. And that's you?
Yes, sir.
Present with Mr. Turkey, your attorney, and the state's attorney. Does the defendant, as Mr. Laird, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
We just going on paragraph 1.
Yes, sir. That was sufficient.
Allegation 1, paragraph 1 states that on or about April 14th, 2026, in Jefferson County, Texas, you committed the second-degree felony of robbery. Do you understand what you were charged with here?
Yes, sir.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty and found guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. There would be terms and conditions of probation, which are normal and customary to this type of offense. Was there any loss here?
No, sir, they caught him.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Sir.
How do you plead to this as alleged, sir? Guilty or not guilty?
Hey, guilty. Did I say that, Judge?
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Is that yes?
Yes, sir.
Yes, so she can hear. So the court has to hear that. I show you what marked it states Exhibit 1. Did you sign that document?
Yes, sir.
Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
States Exhibit 1 is tendered in
No objection.
without objection admitted. This states you are mentally competent to enter your guilty plea. It's free and voluntarily made. You know what you've been charged with. The indictment's been read for you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. It states so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I'm going to follow this agreement, sir. If nothing further, I'm going to find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from States Exhibit 1 admitted to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this second-degree felony of robbery. I am following this agreement. You are hereby sentenced to confinement in the institutional division prison for a term of 10 years. That confinement will be suspended. You were placed on regular probation for 10 years. There will be terms and conditions of probation, which are in this probation order that the court is signing. Please make sure you follow this. If you fail, your probation could be revoked and you can be sentenced to up to 10 years in prison, which we don't want. So do well on this and move on and be the best you can be.
Yes, sir.
All right, I've signed these documents. Please see the probation officer and understand, sign those, and you begin probation. Good luck.
These courtroom moments prove that every case has a different outcome, and one decision can change a person's future forever. If you enjoy real courtroom breakdowns, judge reactions, and the stories behind the verdicts, make sure to hit subscribe and turn on notifications so you never miss our next video.